Okay, whilst everybody's coming into the webinar, we'll give it a minute and then we'll get started.
Anyone coming in?
Yep,
Good.
there are. We're up to 10.
Whew.
Okay, so I'm going to go through the attendees' rules of engagement. This webinar is being recorded. No one can see that you're attending unless you would like to ask questions. So please, if you'd like anonymity during the question and answer, please tick the box to send anonymously.
Could you take him out of here, love?
Before sending your question. You may ask the question at any point, but they will be answered after all the talks. If we don't get through your questions in the allocated time, which is around an hour, we'll see how we go. For this evening, we're going to answer them by email after the session. Okay, so tonight's agenda, Dr. Lawrence Gobetz from Vitalab is going to be talking about surrogacy, egg and sperm donation. Andrew Martin from Fertility Law is going to be talking about surrogacy and the donor legal process. And then Michael Johnson Ellis and Wes from Two Dads UK are going to be talking about their personal journey. And after which we're going to have a question and answer session. So I'm going to just kick us off. Thank you for joining us on our final webinar for Reproductive Health Month South Africa 2021. My name is Saskia Williams and I'm the founding director and CEO of IFASA. I'm proud to be bringing you this Reproductive Health Month campaign and these webinars to you in association with the amazingly talented ladies of House of Fertility Media, Lucia and Michelle, and as well as the IVF Babel Africa team. During Reproductive Health Month, we brought you webinars every Tuesday and Thursday evening throughout February, featuring local and international speakers and specialists, the recordings of which are on our YouTube channel. We are also running an early detection campaign with participating clinics offering 25% discount on your initial consultation and scan if you register through our website, www.reproductivehealthmonth.co.za. So let's get this evening started. Our first speaker is Dr. Lawrence Gobetz. Dr. Gobetz is a reproductive medicine specialist and director of Vitalab Fertility Clinic. He'll be chatting about a fertility clinic's procedures regarding surrogacy and donor cycles, as well as when to consider egg and sperm donation. Over to you, Dr. Gobetz.
Thanks, Saskia. I just want to know that my screen is coming on there. Good evening, everybody. And Saskia gave me a topic that I have to do in 20 minutes, and each topic deserves a 20-minute discussion. So at the end of the day, the questions about when to choose your treatments, etc., I think it's a very sensitive issue, and that really needs to be discussed firstly with your fertility specialist. So, sorry, now my Mac's decided to hang. So we were talking about Mac and now it's hanging. Okay. So I think the most important thing, which is the difficult issues, you know, we used to the standard cultural aspect of what's a family. I think, Saskia, I must get in and share my screen rather, because I think this is.
We can see it fine, Dr. Gobetz.
Yeah, but if
you prefer to share your screen, go for it.
It's not that, it's just, okay, let's see, maybe we'll be fine now.
We can see it fine on the attendees side. I think you'll see the four of us here.
Yeah, I know, great. So, you know, again, what is the definition of a family? And it's a group of one or more parents and their children living together as a unit. So, you know, that can be, you know, if we talk of the old days, a family was, you know, a husband and a wife, and at the end of the day, you had your children and everyone got on with it. And just the thought of the mother-in-law thinking differently, you know, that perhaps we would come home in the same-sex relationship, or etc. And you know, we've developed, and the world has changed. And yes, if we look at what South African law says, and this I'm going to leave to Andrew, and what the definition of a family is, and the traditional nuclear family form is based on the relationship of a married man and a woman and their biological and adopted children, does not reflect the reality of our society, and not necessarily our society. I think every society throughout our planet. And at least the Children's Act 2005 said that parents need to care for a child, we need to keep contact with the child, we need to act as a guardian of the child, and we need to contribute towards the maintenance of a child. So, just trying to move on to the next slide. I don't know why the Mac's doing this, but maybe what we do is close some of these things. Sorry, guys. So if we look at the trends of what's happening in the world today, and this shows us exactly that if we look at the green aspect of the slide, that's really from the UK, from the Human Fertilization and Embryology Authority. And in 2000, if we look at same-sex female couples, they went up from 471 cases in 2000 to 4,750 cases of treatment cycles in 2018. And if we look all around, if you look in America, for instance, the use of donor sperm by same-sex female couples has increased to 20% after the legalization of same-sex marriages. And, you know, we had a similar problem in this country, and I don't believe there's any fertility clinics here that would stand on their, or put their last strand on the fact that before 1997, we didn't go underground and artificially inseminate unmarried women. We did, you know, we continued, you know, we're health professionals and we're there to help people. And yeah, we could have got into trouble. But if we didn't help the couples, they were going to get help irrespective, you know, they were going to do their thing about it. And we know we had pictures in the newspaper of a woman running down Norwood Grant Avenue with a champagne cup, glass with a ejaculate in it, and then off she went and did her, as they called it in the newspaper, turkey basting. And she managed to do artificial insemination by just putting that sperm from the champagne cup into her partner's vagina. And our unit started back in 85, and I only joined it towards the end of 89. And the biggest thing that hit the press was the grandmother who carried her own grandchildren. And they came from Limpopo, and there you can see the mother who herself had had a cesarean hysterectomy, which is something that happens today, which is often a good indication for surrogacy. And this granny was 49 years old, and she carried her triplets. Our unit was involved in this, and we had the press, the BBC, and everybody else. I was still a registrar in those days. And yeah, it was, as I say, a very big moment for South Africa, because surrogacy was only in the world starting to get off the ground. And the last thing you wanted is this poor 49-year-old granny to be carrying triplets, which is obviously a very important issue when one is pregnant. And you don't want to overload someone who's older, who may be an older surrogate. So you want to be careful today and look at only putting one embryo back if possible. But things changed for us in 97 when a same-sex female couple presented themselves to the Constitutional Court. And after that, it was legal for us to artificially inseminate single females or unmarried females, which changed the horizon for us, because then we didn't have to go underground. And, you know, it was a lot more pleasurable working under those circumstances. Now, again, there we go. Right. So if we look at the available types of fertility treatment for these people, and we are starting to look at, I'm really sorry that this Mac is playing up. Michael, your Mac played up and now mine's playing up. So, okay, so if we, you know, artificial insemination is something that one can apply either to single males or typically to same-sex female couples. And we can utilize known sperm or unknown donor sperm. Known sperm is a whole different ballgame, and Andrew, I hope, will go into that with regards to rights to the child and the upbringing of that child in relation to the fact that you now have a known donor, whereas the donors are themselves protected from an anonymous point of view. Some recipient couples want to be able to for their offspring to actually meet their donors later on, and that's one of the reasons why we use a lot of American sperm, because the couples can choose via the profiles of the donors of whether they're willing to meet the offspring that has been achieved by using their donor sperm, and that is when the child reaches the age of 18. We can then artificially inseminate in the lab and do IVF, or we can do intracytoplasmic sperm injection. And again, then that would come into play rather when we are talking about surrogacy, or we are dealing with reproductively older single females or same-sex couples, where you need to get them pregnant sooner rather than later, and one would then be forced to use artificial assisted reproductive technology. So again, they're the same thing, you know, your own gametes. And again, will it be one of the female's eggs? And we have these various different permutations where the one would like to give the eggs. I'm just now talking about same-sex female couples, and the other one will be the carrier. And at the end of the day, you know, that is all legal. And it's just the issue of if there's a known donor as to, I'm talking about from the sperm point of view, what the legalities are. And then from a surrogacy point of view, we do surrogacy often purely for women who've had the uterus removed, especially at the time of the Caesar, and they have one child, and they now obviously the only way of enlarging their family is via surrogate. And also then typically for same-sex male couples, and fortunately we have Michael today, who's obviously going to broaden out on that. And there again, depending on circumstances, one can use donor eggs. And from a surrogacy point of view in our country, one of the commissioning couple have to contribute one of the gametes. So it's either, if it's a same-sex male couple, we use donor eggs and one of the male sperm. And if it's a same-sex female couple, one of the eggs have to be used. You cannot use donor eggs, and we can't do surrogacy for a single woman. So at the end of the day, it is quite complicated, and the legal things, you would then obviously seek help from a person like Andrew, who's a fertility lawyer. You know, we're fertility specialists, we're not fertility lawyers. And we try and steer clear of that, because our job is to achieve the pregnancies and not to get involved with the law and at the end of the day stuck in litigation that we don't quite understand. So if we look at surrogacy in South Africa, we look at criteria, and yeah, sometimes you're stuck because surrogates are you don't pick them off trees on the one hand. On the other hand, you know, there's certain characteristics that one would be looking for, and the age is somewhere between 21 and 42, although that's not a limit. I mean, we could take a 45-year-old or 46-year-old, provided she's healthy. And they need to have obviously good health. And if they are in the older age bracket, we would send them off to a physician to get a clean bill of health. The surrogate has to be a South African citizen and has to have at least one child of her own. The surrogate preferably should be employed, not absolutely, it's ideal, and should be able to show financial independence. The surrogate would undergo medical screening. She will need to be seen by a fertility specialist, obviously the necessary work, and then she would need psychological screening. If we look at the criteria for the commissioning couple, the couple need to domicile in South Africa. The surrogacy by right is not allowed for foreigners. And, you know, with fertility today and transporting gametes and eggs and sperm and embryos in dry shippers outside of the country is something that one can do. And then the embryos can be transferred in a fertility clinic in their home country. So again, there's certain areas which become loopholes, and I'd leave that one for Andrew to comment on. But we would be careful not to do foreigners in our country unless, as I say, they have proven that they domicile here and they have South African citizenship. As I said, you have to use at least one of the commissioning couple's gametes and medically incapable of carrying their own child. And that can be very broad, okay, as to what the reasons would be and why they can't carry their own child. It could be for psychological reasons. It could be for medical reasons. It could be because they don't have a uterus, or it could be where they've done numerous IVFs with recurrent implantation failure, and we now need another oven. So off to the next slide. Come on. We have our own egg bank. We did start, we felt that it was prudent to only start putting eggs in the freezer when we could document that the technology that we were using was robust. And we started with robust technology in 2013. And when we had a functioning egg bank, we would then actually advise patients to come and use the frozen eggs, and we were getting pregnancies very much the same as fresh eggs. So unfortunately, there are lots of eggs sitting in liquid nitrogen dewars having been frozen before technology was robust. And those patients are only finding out now that unfortunately those eggs have not survived, and they become nothing. You can't really use them. Now and again, we'll slip through with an egg that may be able to survive and give a baby, but the majority of eggs frozen prior to 2013 really or they come to naught. The donors that we use are between the age of 18 and 32. They need a matric. Their BMI has to be 29 or less. Obviously, all race groups and nationalities. We check them for drugs. They screen medically. They screen psychologically, and they have the relevant counseling. We have a program on the computer where we give the patients an opportunity to actually look at these donor profiles in the comfort of their own home, and then choose accordingly. Donors are not allowed to have more than 6 live births, and that includes their own children. And then it costs somewhere between 60 and 135,000 for the whole cycle of treatment, including the eggs and IVF, for the couple who are the recipient couple of the donor eggs. From a sperm donation point of view, we also have a small lab. There are lots of other labs within the country. There's some in Joburg, Cape Town, Stellenbosch. And the reason why we use overseas sperm donors is that, firstly, the variety is amazing. You get a lot more information on who the donors are. And at the end of the day, as I say, some patients would like to know that they can introduce their children later on to the donor. We do use known sperm donors, again, with the necessary consent. It's not just taken and used, because if you don't have the legal issues as to what is the rights of that father to that child when there is no real family connection, and that we use, our clinic assesses that, and obviously we need the legal documentation to proceed. Donors are not allowed to have more than 12 live births in this country, and at the end of the day, the price range per straw local is somewhere in the region of 3 grand, and if we're bringing in sperm from overseas, it's about 15,000 rand per straw. And one straw, if we're doing IVF, is more than enough for a few cycles of IVF. If we're doing ICSI with that one straw, we've got more than enough to work with. And at the end of the day, it's not that costly. As far as what we're addressing today, this group of patients is growing, as I showed you in the initial slide. We know the World Health Organization defines 52 different genders. And at the end of the day, there's a lot of research and resources, okay, specifically for our LGBTQ2S plus group. And you can look down where that arrow goes to Queering Parenthood. There's the email address, not email, the website address, and that's www.queeringparenthood.com for anyone who wants to go there. And there's a lot of research now showing that, unfortunately, a lot of these couples, especially when they're undergoing transgender change, there's a problem in that a lot of them are not counseled correctly. And today, if we look at studies in Belgium and Western Europe, at least up to 77% of them want to put their gametes away in storage. And what's important is obviously to do that prior to hormone therapy or surgery or in conjunction with those procedures. So our options for persons with testicles would be obviously sperm banking, and our options for persons with ovaries would be egg banking, embryo banking, or even ovarian tissue freezing. One last slide and we're nearly done. So we are quite proud that we do help these families, and we've been helping them for many years in assisting their fertility treatment. We have very supportive medical staff. There's nobody there that judges anybody at the end of the day, and it's regardless of marital status or sexual orientation. And we understand that you know, the fertility options they're difficult for these patients, and there needs to be the necessary backup. And we have created a comprehensive fertility program that encompasses the medical, financial, legal, and emotional obstacles that these couples face. And finally, I will be available for questions afterwards. And when I asked Calista to just tidy up my slides for me, she said, "Do you want a funny slide at the end, or do you want a real serious slide?" So I said, "No, let's have a funny slide." So thank you, guys. And on the right, that's a very old picture of me. Thank you.
Oh, that's brilliant, Dr. Gobetz. Thank you very much. That was a fantastic presentation. And yes, as you said, it definitely wasn't enough time to go through all of it in depth. So people that are interested in finding out more, please contact Dr. Gobetz, follow Vitalab on Facebook, Instagram, and you can find out details, or ask your questions now, and we'll go through them afterwards. So next up is Andrew Martin. Andrew is the founder and director of Fertility Law, and he's going to cover the legalities around surrogacy and donor cycles. Welcome, Andrew. You need to start your camera and unmute yourself.
You can't start your video because host has stopped it. Saskia, can you restart my camera?
Sorry, there we go.
There we go.
There you are.
You blocked me. Right, evening. Thank you very much for giving me the opportunity to come and talk and present. It's always a little humbling to follow Dr. Gobetz with his beautifully collated slides, but I'll do my best to give you some interesting information from my perspective on the legalities surrounding surrogacy and donation cycles. I'm also going to talk, well, a rather large portion of what I'm going to talk about this evening is also relating to parental rights and responsibilities for specifically same-sex female couples. We are currently involved in some litigation at present involving the Minister of Home Affairs and the Director General of Home Affairs. So I will kind of circle back to that. I don't, unfortunately, think there's enough time for me to go into the intricate details of the law relating to both surrogacy and donation as much as I'd like to give as much detail as possible. But let me at least start from the perspective of gamete donation in South Africa. Interestingly enough, South African law predominantly is managed through the regulations, artificial fertilization of persons, which is a regulation of our National Health Act. It regulates the issue of gamete donation in South Africa, and predominantly all gamete donation, as Dr. Gobetz touched on, is done on an anonymous basis. Our regulations do make provision for known donation, but it's rather silent as to how one regulates it. So what we do in practice is that we encourage parties to enter into what we call a known gamete donation agreement, in which we then regulate parental rights and responsibilities of both the recipient parents and the donor. Predominantly, in the past, we used to find that most gamete donation scenarios were done in that the identity of the donor would remain anonymous from the child. But over the last couple of years, we've started to see a development within South African kind of practice, not necessarily in the law as of yet, but this idea of an identifiable donor. It hasn't quite taken hold within our legislation because our legislation specifically kind of prohibits the identity of the donor from being made known, but very hard to police and regulate. So the idea of, this is where the idea of the identifiable donor is coming in. I do envisage some kind of changes starting to appear within our law, allowing for identifiable donors, or at least allowing for court applications. At present, there's a possibility that one can approach the High Court for the doctors involved in the donation of the gametes to allow for them to release the identifiable information of the donor, obviously with the donor's consent, but that's a relatively complicated and or expensive process that one would need to go through. So in essence, what I'm advising people to do if you're going through a known gamete donation, including a known embryo donation scenario, is to contact a fertility specialist attorney who is affair with known gamete donations agreements, and to have an agreement drawn up. Our law is very specific when it comes to someone who is classified as a gamete donor, and in that respect, our law specifically confirms that a gamete donor does not obtain parental rights and responsibilities. So the minute one has the intention to be a gamete donor, then one automatically, in terms of the Children's Act, doesn't obtain any parental rights and responsibilities. One can always vary that by way of a parental rights agreement, which can then be made in order of court to give it legal standing, or to give it more of a legal standing. But predominantly, and the simple way of doing a known gamete donation is to keep it simple. The gamete donor doesn't get any parental rights and responsibilities, and his identity remains anonymous. However, as I said, we're starting to see a shift. So a known gamete donation agreement or a parental rights agreement can make provision for that identity to be known in time. But at present, identity is advised, or in terms of our law, kept anonymous. When one is using an anonymous donation, there's no need for legal agreements to be put in place. The fertility clinics and all the donor agencies take care of the relevant consents required to be signed by the donor and the recipient parents, and the fertility clinics themselves and the doctors treating the recipient parents and donor will then are legally obligated to keep that identity or that information strictly confidential under penalty of criminal sanction. So the law surrounding donor gametes is definitely going to be changing in the coming years. There's a trend within Europe and the rest of the world to make donation either completely known or to make it completely identifiable once one turns 18. So this is predominantly what we find in jurisdictions such as Australia, where recipient couples and or children born as a result of donations are able to access donor information from central government controlled donor data banks and obtain and contact donors at a later stage. At present in South Africa, we don't have a donor registry. There is a voluntary registry created by SASREG, the governing body of fertility clinics, but that is more there to assist fertility clinics in tracking live births versus making the identity of donors available. Okay, so enough on gamete donation. If you'd like more information, you're obviously welcome to look at our website or give me a call. I can quickly touch on the legal aspects of surrogacy, but I'd predominantly like to talk about the court case that we're dealing with in the same-sex female couples. But from a surrogacy perspective, South Africa is a very unique jurisdiction within the world in that we actually have legislation that regulates surrogacy. It is found in Chapter 19 of our Children's Act, and it specifically requires parties undergoing surrogacy to approach the relevant high court in the jurisdiction in whose jurisdiction they reside for an order in which we confirm the parental rights and responsibilities are that of the commissioning parents, that there is no need for an adoption procedure to proceed, and that the names of the commissioning parents are placed on the birth certificate from the moment of birth. I pause at that point to give you a little bit of a history lesson. Prior to Chapter 19 of the Children's Act coming into effect, which was in 2007, the surrogate mother was considered the biological mother of the child, and she would then automatically obtain parental rights and responsibilities. And as a consequence of that, she and her partner, if she was married or in a relationship at the time, would automatically obtain parental rights and responsibilities, and then their names would go on the birth certificate. The parties would then need to go through a known adoption process through the Children's Court, which, although relatively simple to manage, was an unnecessary step for commissioning parents to go through. And it's one of those, and I'm sure Michael and them are going to talk about their journey through obtaining parental rights orders in the UK. But similarly, a known donation is a similar kind of scenario. But luckily in South Africa, we now have Chapter 19 in the Children's Act, which provides certainty to both commissioning parents and surrogates. So the surrogate on the one hand knows that she doesn't have parental rights and responsibilities, and the commissioning parents know that from the moment of birth, they have full parental rights and responsibilities. The court application goes on to confirm the written surrogate motherhood agreement that we enter into between the parties, which ultimately regulates their relationship, issue of payments for medical aid, life insurance, those kind of things. Together with, we get the fertility clinics and competent persons and doctors treating the couples, we authorize artificial fertilization. That portion of the court order is valid for a period of 18 months. So you have literally got 18 months within which to get pregnant. There's a relatively simple process to extend that time period if one were to run out of time within the 18 months. We also have the surrogate agreement and court application specifically declared confidential. And then we have recently introduced further prayer to our papers in which we confirm ownership in the embryos which are created as a result of the artificial fertilization process. The regulations to the National Health Act confirm that ownership in an embryo created for the purposes of artificial fertilization vests in a recipient. And on a strict definition and understanding of the term recipient, your surrogate then technically becomes the owner of your embryos. So our surrogate motherhood agreements and our court order and application confirm a transfer back of ownership to the commissioning parents. It's more of a crossing T's and dotting I's thing that we do versus no fertility clinic really would act on a surrogate's instructions, but someday in the near future, we might see a surrogate trying to enforce her ownership rights in the commissioning parents' embryos. So we try and take that dilemma off the table by confirming a transfer of ownership. So Dr. Gobetz did touch on the requirements for surrogacy in South Africa. Briefly, they are that one must be domiciled within South Africa, one must have a condition which is permanent and irreversible, one must have a genetic link to the child, one must be shown to be a suitable person to be a parent. We confirm suitability by doing quite stringent clinical psychological assessments, criminal background checks, as well as doing various medical screenings to check, not that having HIV makes you unsuitable, but it is certainly a request by the court to show HIV status, STDs, and any other transmissible disorders. And similarly for the surrogate, we also show that they're suitable individuals. So we show clinical psychological assessments, criminal background checks, and medical suitability to be a surrogate. Must have a living child of her own, must be medically able to carry a pregnancy, doesn't have HIV and any STDs at present. We're currently involved with a surrogacy involving HIV patients. So it's not unheard of. The court is amenable to doing surrogacy with patients with HIV. You just need to have the necessary precautions put in place. So look, as I said, I would really like to talk about the same-sex parental rights thing, but if you do have, again, questions relating to requirements for surrogacy, please drop me a line. I'm more than happy to answer questions hereafter as well. But a burning passion of mine at present is the application which we have pending before the Pretoria High Court. In 2019, we successfully brought an application in the Western Cape Division in front of Judge Parker, in which we were able to successfully ask the court for a preemptive order confirming the parental rights and responsibilities of both the moms to be in the same-sex female couples. Why we have done that, or why we did that, was in terms of the Children's Act, which Dr. Gobetz touched on, is drafted predominantly from a heterosexual traditional family relationship makeup, having the mom who gives birth to the child and the father who is genetically linked to the child. Our act is interesting in that it doesn't define genetic mother or father. It uses the term biological mother or father, which is undefined in the act. And the reason for that is that the act allows for parents who are married, who are not genetically linked to the child, to obtain parental rights and responsibilities. But our act predominantly sees parental rights and responsibilities in a heterosexual relationship. The mother who gives birth to the child is automatically assumed to be the biological mother, and she automatically obtains parental rights and responsibilities. And the partner, father, husband of the biological mother then automatically obtains parental rights by virtue of his relationship. And it is assumed that he's then the genetic father of the child. So it is in that light that the non-biological partner of the biological mother, or the non-genetic partner, non-genetic parent of the biological mother, doesn't automatically obtain any form of parental rights and responsibilities under our current legislation. So there is a bit of a lacuna in our law at the present. Same-sex male couples are required to obviously have a pregnancy carried via surrogacy, so they're required to go through the provisions of Chapter 19. So parental rights and responsibilities are dealt with in terms of Chapter 19. Heterosexual couples automatically obtain parental rights and responsibilities by virtue of our provisions in the Children's Act, but same-sex female couples are kind of left in limbo as to an automatic assignment of parental rights and responsibilities. So the scenario that a lot of couples have found themselves in is that they are either A, required to go through a process of a known adoption post-birth, or alternatively to enter into a written parental rights agreement in terms of the Children's Act. So what we did in 2019, we successfully brought an application to argue that the rights of the non-genetic, non-biological mother are being infringed, together with the rights of both parents to make decisions relating to their reproduction rights, as found in Section 12 of our Constitution, for them to approach a fertility clinic or to do home insemination, for them as a couple to make the decision to have a child together as a couple, and for both of them to automatically obtain parental rights and responsibilities. So what would often happen is that couples would then arrive at the Department of Home Affairs to register the birth of their child and be told by the official dealing with the birth registration process that, well, I'm a little bit confused, I don't understand. I can't have two moms on the birth certificate. Where's the father? I can't register their birth. And we'd have a lot of problems in the past with registration of birth. Sometimes Home Affairs would be willing to just register the birth. So currently at present, we have a matter pending before Judge Newkirker in the Pretoria Division, in which she has requested that the Center for Child Law be appointed as an amicus curiae to provide us with representations as to what is in the best interest of the child. At present, the moms are, well, the one mom is actually pregnant. She is 35 weeks pregnant as of this week. So we have a curator ad litem appointed for the unborn child to represent his rights. And we are waiting on whether the Minister of Home Affairs will be opposing the application or the relief which we seek, which ultimately is going to be that we are going to look to have provisions, or the provisions of Section 40, subsection 3 of the Children's Act declared unconstitutional, and for certain wordings to be written into the section so that same-sex female couples can automatically obtain parental rights and responsibilities. That matter has been postponed until the 19th of March. So we're hoping for it to go forward then, and for the judge to, well, for Home Affairs not to oppose the matter. We don't anticipate that they will be opposing the matter, but we do hope that the judge then writes a judgment for us, which we can then take onto the Constitutional Court and have made final and binding, and then to instruct the legislature to make the necessary required amendments to the Children's Act. The reason which we are very confident about this is because in 2003, which was roughly 2 years before the Children's Act came into effect, there was a constitutional court judgment which declared the provisions of the Child Status Act unconstitutional. The section within the Child Status Act was basically copied and pasted and put into the Children's Act. So the wording was changed only in as much as they changed and introduced the word spouse to section 40 subsection 3. So we are confident that there will be a constitutional amendment which will ultimately assist same-sex couples in automatically obtaining parental rights and responsibilities. However, in the interim, there is no guarantee that there is no automatic assignment of parental rights and responsibilities. So we then advise couples to approach the relevant High Court for a declaratory preemptive parental rights application, in which the High Court, in its capacity as upper guardian of all children, then makes an order confirming that both mothers have parental rights and responsibilities, and that the gamete donor, be it an anonymous gamete donor or a known gamete donor, have no parental rights and responsibilities. So the matter pending before the Pretoria High Court, there is a known gamete donor involved in the process. We actually are in the Durban High Court tomorrow with a couple that are, she's 37 weeks pregnant as of present. She's about to give birth next week Friday, in which they're using an anonymous donor. So, and in that case, the Department of Home Affairs has indicated that they don't intend opposing the application. So we're hopeful that we'll get an order in the Durban High Court tomorrow, and we're hoping that we'll get a judgment out of the Pretoria High Court in the 19th of March, and then proceed to change the law in South Africa so that we can make it easier for same-sex female couples to automatically obtain parental rights. Because in my opinion, it's a complete infringement of one's dignity, right to equality, right to make decisions relating to reproduction, if one has to then potentially go through an adoption process, or enter into a parental rights agreement, which ultimately is only designed to regulate parental rights and responsibilities of couples that have separated after the birth of their child. So it regulates contact and care in two different households, and is not really defined, is not really created for the purposes of regulating parental rights and responsibilities within a household. So there isn't at present a means for same-sex couples to automatically get. So the court order has worked. We've brought a number of successful applications throughout the various divisions in South Africa. At present, Judge Newkirker is of the opinion that she would like to write a judgment, and hence us waiting for the return date to the 19th of March. So Saskia, I'll pause there to give some of the other attendees chance to talk, because I think I might have spoken a little bit too long, but I certainly am amenable to answering any questions, either known donation, surrogacy, parental rights and responsibilities that any parties have.
Thanks, Andrew. Thank you very much. And there are a couple of questions for you in the Q&A, so we'll go through them afterwards. Mike, are you ready? I think I might have to allow you to have your video on as well. But let me just introduce you first. Michael Johnson Ellis is one half of Two Dads UK, and he's going to be talking about their personal journey with surrogacy and what they do there. So, he's sharing.
Yeah.
You still need your video?
Yes.
Now I don't know how to do it.
Pop it on anyway. It'd be good to still be kind of there.
I'm not sure I know how to do it now that you're sharing. Hang on a sec.
Or I can stop share. I was only going to share for a little bit.
Okay, stop share for now. Let me allow your video so we can see your lovely face. There we go.
There we go.
There you are.
Wonderful. Shall I still share?
Yes, go for it.
Okay, wonderful. Right. There you go. Can you all see my screen, yeah?
Yes, we can.
Wonderful. Okay, so hi everybody. Thank you, Andrew and Dr. Gobetz, for those insightful presentations. So, as you can see, I'm one half of Two Dads UK. So I'm Michael, and I'm married to Wes, and we have created Two Dads UK. So we created Two Dads UK back when our surrogacy journey began, to help destigmatize surrogacy and to help normalize same-sex parenting in the UK. The account has gone on to grow in popularity, and we assist and support and guide people from all over the world in terms of understanding surrogacy. Now, our journey took place in the UK. So obviously, to carry out UK surrogacy, you do have to be domiciled in the UK. You don't necessarily need to be a UK citizen, but you do have to be domiciled, which is slightly different to registered or being a citizen. So in this particular presentation, I'm going to talk through our journey from all the way from where our journey began to where we are now. So I married Wes I met Wes first of all in 2012. And when I met Wes, he already had a daughter. So had previously been married to a woman and had a daughter from that marriage and relationship. And her name was Katie. And Katie was 7 years old when we first met, and she's now 16. Wes and myself have two children together. So we have a little girl named Tallulah, who's 4 years old, and we have a little boy who's 18 months old, and his name's Duke. So we created Two Dads UK with a number of objectives, as I mentioned, and that was to destigmatize and to normalize. We've since gone on to create Two Dads UK and the Modern Family Show, which is the only UK LGBTQ plus family building event, which takes place in London in September of this year. We've also recently created a non-profit surrogacy organisation called My Surrogacy Journey. We continue to raise awareness about UK surrogacy and or support other people on their own surrogacy journey. And we support intended parents, intended fathers and intended mothers with all of the information that they require to help have a safe and secure journey. We also support and work with healthcare professionals in the UK to help educate and to help use the correct terminology when working with intended parents. So whether they are LGBTQ or heterosexual, we'll work with UK healthcare professionals to use the correct language when working with children born through surrogacy. We've been instrumental in helping with the law reform in the UK. So we've campaigned heavily to allow for a change in the law. And we were involved last year in the law commissioners for England, Scotland and Wales for the change of law of the surrogacy reform. Currently, the laws state in the UK that any child born through UK surrogacy, the surrogate is the legal mother of that child. And if she's married, then her husband or wife would be the other legal parent. Now, you have to apply for a parental order to become the legal parents of your child, but you can't do that until your child is 6 weeks and 1 day old, currently in the UK. Once you get to that particular time point, what you then do is you submit your application to the court, and then usually after about 3 to 4 months, that is granted in the magistrate court. It's a very straightforward process and is usually completed within 15 to 20 minutes, and the intended parents are then granted the legal rights to their child. Surrogacy in the UK, one of the intended parents currently has to be genetically related to the child. So in our case, we had an egg donor. Egg donation and sperm donation in the UK is what is classed as non-anonymous. So what that basically means is that at point of donation, the donation is completely anonymous. There are no photographs, there are no images of those donors. All that is identifiable are certain characteristics. So their skin tone, their height, their age at donation, and their complexion. And then when the child becomes 18 years old, they can request full disclosure of the donor. And if they want to then contact the donor, then they can do once they become 18 years old. In terms of the way our family was created, so our first child, Tallulah, is biologically linked to me. So we used my sperm and we had a gestational surrogate. So our surrogate wasn't using her own eggs, she was purely a host. In the UK, you can only do altruistic surrogacy. So commercial surrogacy is forbidden and is illegal, but altruistic surrogacy is perfectly acceptable. And that basically means that a relationship with the surrogate has to be formed, and only reasonable expenses can be paid to that surrogate, who must reside in the UK for that journey to complete. So our surrogate was based and lived in the UK. She was a host surrogate, and the clinic sourced us an egg that matched my husband's characteristics. So when we were building our family, my husband and I look quite different, although we both don't have any hair. I'm olive-skinned, brown eyes, and darker features, and he's fair-skinned, blue eyes, and lighter hair. So the clinic actually found us a blue blonde fair donor, which took around 4 months to find. And when they found that donor, those eggs were retrieved, and I fertilized those eggs with my sperm. We froze the remaining embryos, and we transferred one of those embryos into our surrogate. In terms of my further presentation, there's a point that I also wanted to mention, which I should have done at the start, but that was just this particular point here, which is an interesting stat, which again backs up some of the information that Dr. Gobetz was referring to. And that 77% of LGBTQ plus people between the ages of 18 to 35 are either already parents or considering having children, which I think is a huge increase on our elders, and certainly demonstrates the scale of LGBTQ plus family building, and that more of us are turning to reproductive medicine than adoption or fostering or co-parenting, which is what our previous generation would have done. So that goes to show that millennials are definitely looking more towards reproductive science. In the presentation here, I do have a history slide which kind of refers to what our journey looked like. So you can kind of see that a surrogacy journey, our journey, we had 3 years of research. So we looked at international surrogacy, and then we decided that UK surrogacy was best for us. And then this particular slide kind of demonstrates the journey of which we went on. So it certainly was one that was heavily invested in time and in finances. But it was definitely one that was done with a ton of research. And it was that research and that information that we learned, and all of the skills that we developed as to why we do what we do now. So my husband and I have completely changed our careers. I write for the fertility industry now, as well as blogging and hosting our channel, Two Dads UK, and other bits of work that we do. So completely have changed my calling for assisting and helping those that are trying to conceive to build a family through surrogacy. So this particular slide then shows you our journey. So you will see as we move through that our daughter was born in 2016 on the 16th of October. And after she was born, we decided after about a year to start our journey again. So that began, but unfortunately in 2018, we had a failed transfer. And unfortunately, we also lost all of our embryos as a result of a particular issue with that clinic. What we did following that is that we took a few months break, and then we embarked on fertility treatment again. And then we were very successful in having our son Duke born in August 2019, again with the help of our amazing same surrogate, which we are totally grateful for. But as I've explained, surrogacy in the UK is completely legal. Whilst the parental laws and parental responsibility isn't granted at birth, the process is fairly straightforward. If you are looking at surrogacy in the UK, then there are a number of non-profit organisations that can help you. One of those being Surrogacy UK, Brilliant Beginnings, and My Surrogacy Journey. I am conscious of time. What I did want to say is that through all of the work that we have done, we have gone on to do a ton of campaign work and media work to help normalise and to help change policy for our community. So that's definitely some of the work that we've been doing, and that is all highlighted on our screen now. So by all means, if you do want to get in contact with us, you can via our website, which is www.twodadsuk.com, or you can follow us on any of our social media channels, which is twodads.u.k. Thank you very much for listening.
Thank you, Mike. Thank you so much. And everybody needs to follow you on Instagram. I think you've got Instagram Live later.
I have, yes.
This evening, don't you?
I do,
At 8 o'clock your time.
Yes, correct.
Okay. So follow Two Dads UK on Instagram, and then if you're not up at 10 o'clock our time tonight, you can watch it. You can watch it tomorrow.
Thank you.
Thank you very much for joining us. And your family is just beautiful. And thank you for everything that you're doing on your side. And we do actually have a couple of questions from people that are based in the UK wanting to do treatment this side. Maybe they think they're coming to some sunshine, but however, this evening we've had a lot of rain. Whilst you were talking, I felt a bit like I was back in the UK. So Gobetz, I see that you've answered some of the questions that we had.
Yes, I have.
Perfect. Thank you. There's a couple of questions for Andrew. Andrew's had to leave with a 2-year-old emergency. He's got a 2-year-old that he needed to deal with, so we can all understand that. So the questions for Andrew, please can you email them to me, saskia@ifasa.co.za. I do have an answer about the identity of the donors. The question was it if at the moment the child does not have access to files of the egg donors, if the law was to change, would access to such information, would the law be retroactive? And it won't be. It will never be retroactive. So that question is answered. The other question, please email it to me. Dr. Gobetz has answered the other questions. Dr. Gobetz, did you answer the ones about accessing treatment here? Dr. Gobetz, do you know offhand if a surrogate, do they need to take the legal contract to the hospital?
No. You know, the surrogates, all the documents will be in the commissioning couple's file. The surrogate would also have her own medical file. So when the surrogate is now being treated by the gynecologist or the OBGYN, she is now the patient. And she has her own file with the obstetrician who's now going to look after her from an antenatal care point of view and then do her delivery. And all the notes that need to be done will then be in her file. So you now have a legal document that, and we know, prior to it, we would travel up and down the streets of Sandton going to the lawyers to have to sign off the adoptions. And when the law changed and when they took the Surrogacy Act from our Healthcare Act and they put it into the Childcare Act, immediately once that document is stamped in the High Court, the commissioning couple are the parents. So the minute the child is born, with the necessary legal documents, the commissioning couple then appear on the child's birth certificate, and the surrogate who gave birth has no longer any rights to that child. So you've got to see it in context of the patient who's the surrogate is now the patient of the gynecologist. And she is dealt with as any normal patient, but once she gives birth to the child, then the law fits in, and everything is then via the legal channels.
Perfect, thank you. And then that last question from the person from Mozambique, who's a bioethicist and would like to know how surrogacy works in South Africa and how is the issue of sperm or egg donation conducted?
You know, the question, and I don't know if it's open or not, but is this a single male who is now not living in South Africa wanting to use a surrogate with donor eggs in our country? And I don't know if the patient is prepared to qualify that or whether they would want to deal with this personally, and they're welcome to email me at Lawrence G, LAWRENCEG @vitalab.com, and we can gladly answer that for him.
Thank you, Dr. Gobetz. So that's all the questions that we've got. If anybody's got any other questions, please email them to me or connect with Mike and Wes via Instagram or email Dr. Gobetz. And we've had some feedback. Someone's saying, thank you, very informative webinar. So thank you guys for giving up Dr. Gobetz your time this evening, Mike, your time this afternoon. We do appreciate it. Thank you so much. And that's a wrap for Reproductive Health Month 2021.
Amazing. Thank you.
So thank you guys, and thanks everybody who took part in watching our webinars. This will be uploaded tomorrow onto our YouTube channel. And everybody keep well, stay safe, and we'll see you National Infertility Awareness Week in June.
And just a thank you to Saskia for all her effort and for the great month that has she's undertaken, and all the trouble that she's taken to get everything onto YouTube, etc., and all the information that she has shared with everyone out there. I think it was a phenomenal effort, and well done, Saskia.
Thank you, Dr. Gobetz. I appreciate that. And it wasn't just a lone task, it was House of Fertility as well. And IVF Babel Africa introduced us to Mike and everybody. So thank you, Dr. Gobetz. I appreciate that. Thank you guys. And thank you for giving your time and your expertise. And we really do. It really helps, you know it does. So keep well, guys. Bye.
Thank you. Ciao, ciao.